Welcome to How to Double Your Economic Damages in Medical Malpractice Cases. I'm Philip Vondra, Chair of Beverly Hills Bar Association's Personal Injury Law Section. I'm delighted to introduce our speaker, John Medler. John Medler is a founding partner of the Medler Law Firm, where he spent more than 35 years representing individuals and families in serious personal injury and wrongful death cases, including medical malpractice. He has secured tens of millions of dollars in verdicts and settlements on behalf of injured clients, with results ranging from a $15 million wrongful death judgment to a $14 million helicopter crash verdict, among many other seven-figure recoveries. John is a lifetime member of both the Million Dollar Advocates Forum and the Multi-Million Dollar Advocates Forum. Holds an AV Permanent rating with Martindale-Huddle and is board certified by the National Board of Trial Advocacy. He is also a member of the Consumer Attorneys Association of Los Angeles. And now let's get started.
Good morning. Pull up my presentation here. My name is John Medler. I'm a personal injury lawyer. I am in Newport Beach, and I do personal injury and medical malpractice cases along with my son, Ryan Medler. So we have sort of a father-son practice together. And this seminar is called How to Double Your Economic Damages in Medical Malpractice Cases. Any of you that practice in medical malpractice in that area know that it's very difficult. Cases are hard. It's difficult to get a verdict because jurors naturally believe in doctors. Sometimes in scenarios that just don't make absolutely any sense whatsoever, but they have a tendency to vote for doctors in many cases. They're very expensive. There are limits on damages, and so we fight the good fight. And many of you know that in medical malpractice cases, non-economic damages are limited by the Medical Injury Compensation Reform Act, also called MICRA, California Civil Code Section 3333.2, which since 1975 has been kind of the bane of our existence. As many of you know, for like 50 years, non-economic damages in medical malpractice cases only were limited to $250,000, which is just absolutely obscene. You can imagine a case where a doctor cuts off the wrong leg accidentally, and the person's going to have a lifetime of problems, or make someone blind or so that they can't hear or whatever, puts them in a wheelchair for life. And their non-economic damages were limited to $250,000, which is just absolutely obscene. The only people that made any money off that were the insurance companies for the doctors. Fortunately, on January 1st, 2023, there was a modest improvement in that scenario where they tried to increase the limits for non-economic damages over a 10-year period. As it currently stands right now, as of January 1st, 2026, the micro caps on non-economic damages are $470,000 for non-fatal injuries and $650,000 for wrongful death cases. And those amounts will keep increasing by about $40,000 a year until 2033, at which point the limit will be $750,000 for non-fatal injuries and $1 million for wrongful death. But as many of us know, doctors can do very bad things, and they can commit malpractice in ways that seriously impact the lives of our clients. And having limits like that is just absolutely devastating to our clients who've been injured through gross medical negligence. What we want to do, and this is what the focus of this seminar will be, is to try and make the area of damages which is not limited in any way with caps to be as large as we can. And that's, of course, the economic damages. So even under MICRA, even under the draconian scheme that was put forward by the Doctors and Hospitals Lobby, nevertheless, the economic damages of someone injured through medical negligence is still not limited or capped in any way. And when we talk about economic damages, of course, we're talking about things like lost wages, loss of earning capacity, and future medical bills. And so in a case where you've got, for instance, a life care plan for future medical care, sometimes that can run in the millions of dollars. And those are not limited in any way. Future earning capacity could, again, be in the millions of dollars, and that's not limited in any way. So we want to adopt strategies so that we can increase those economic damages to the greatest extent possible. And what we're going to talk about in this seminar is a strategy for increasing your economic damages significantly. In fact, to the point where the amount can almost be 2 or even 3 times greater than the gross number that you start off with. And the key to the strategy is CCP 667.7. This is another provision that was put in by doctors that only applies in medical malpractice cases. And at first glance, it's a terrible provision for medical malpractice plaintiffs, because what it means is that doctors that get hit with a malpractice verdict can take those aspects of future damages, and that includes not only economic future damages, but also non-economic future damages, and they can pay those damages over time. And what do I mean by that? Well, what happens is if the amount is over $250,000 for future damages, the doctors can come in there, and as long as they've asserted this as an affirmative defense in a medical malpractice case, they can come in after the verdict is entered and ask the judge to enter an order allowing them to pay the future damages in periodic installments over many, many, many years. And as you can imagine, if you're a plaintiff who's been injured by medical negligence, you want your money now. You want it in a lump sum like any other personal injury case. But in medical malpractice cases, as long as the doctor has put that as an affirmative defense, he can move for that order after trial and pay over time. And I can assure you from the medical malpractice cases that I have done, the doctors will always put that as an affirmative defense in their answer. So how can we use that provision, which normally would be something very disadvantageous to the medical malpractice plaintiff, and use that to our advantage to increase economic damages? Well, in order to do that, it's important to, if we could, to just try and compare a regular personal injury case with a medical malpractice case so that we can see how this works. Many of you, of course, are personal injury lawyers. You've done collisions with automobiles, crash with the truck, something like that, even products liability cases. And so you're probably very familiar with how economic damages and future economic damages will go in a typical personal injury case. So let's talk about that first, because I think when you see the comparison, you'll see how this strategy can be employed. So in a typical personal injury case, a person may have future lost wages or future lost earning capacity, and they may also have future medical bills. So what happens in a future with respect to those future damages in a medical malpractice case? Well, for many, many, many years, the defendant has argued that to give the plaintiff a lump sum verdict today that includes future damages for things that they will need in the future is unfair and gives the plaintiff a windfall. I would obviously disagree with that, but this is what defendants have said and courts have agreed to for many years. So to just give a quick example, let's say that your doctor gives the opinion that in 10 years, the plaintiff is going to need another fusion surgery to their back, let's say. And he says in today's dollars, that surgery, let's say, costs $100,000. Okay? Well, that plaintiff is not going to need that $100,000 surgery for 10 more years. So the defendant argues, hey, it's unfair to give them $100,000 today in a lump sum for that surgery that he needs in 10 years. Why? Because he can take that money and he can invest it. And even if we don't go into the stock market, even if we just pick a very completely safe investment like treasury bills, treasury bonds, even if we do something like that, put it in a CD, um, even with a very, very modest and safe investment vehicle, they can take that $100,000 that they get today and they can invest it. So let's say they start with $100,000. In 10 years, when they need the surgery, they might have $200,000. And so the defendant then argues, hey, because they can make all this money on their money, it's unfair to give them $100,000 today. So that's why defendants have argued that they should be able to reduce the gross amount of future damages to what's called present value. Many of you are familiar with this concept, of course. And what present value does is it takes your gross amount and it generally will decrease it. So what would happen is, let's take as an example that same $100,000 surgery. The defendant may argue, hey, we only need to give the plaintiff $60,000 today, not $100,000, because he or she can take that $60,000 and put it into a very safe investment. And over time, they can invest that $60,000. And in 10 years, they'll have the $100,000 that they need at that time for the surgery. So because of that, in the typical personal injury case, you're going to see both sides getting economists or CPAs who will come in and take the gross figure that they are given for the wages or from the doctors for the life care plan for future medical, and they will use different formula to reduce that number to present value. Generally speaking, the plaintiff's expert will try and say that the discount rate is lower. And when I say the discount rate, that means the rate of a safe investment. And generally, the plaintiff's lawyer will say that that amount is lower, and the doctor's expert will say that amount is higher. The plaintiff's expert will generally try and put the plaintiff in very, very safe investments, like a CD or like a treasury bill that has a very short period, say 90 days, 6 months, something like that, because those are ultra safe. Whereas the defendant will make the argument that no, we can still safely use a longer term vehicle like a 10-year treasury bond, which is still, in the defendant's view, safer. And the results of using those two interest rates will result in different numbers, of course. And then it's up to the jury to decide which one is more reasonable. And of course, I'm biased, but of course, I believe the plaintiff's view on that is obviously much more sound, because the plaintiff did not decide, oh, I want to take some money and go to Las Vegas and invest and put it down on the craps table. They are not required in a case like this to take their money and invest it in something that is risky. We don't have to buy swampland in Florida. Instead, we are only required to have them invest that money at the safest possible rate. So there'll be a debate, and the plaintiff's lawyer will have an expert, the defendant's lawyer will have an expert, and the jury will decide which one's right. So this issue of present value will be presented by both parties, typically in a personal injury case, to the jury, and the jury decides which one they value more. But the bottom line is, what normally happens is that the ultimate result of both the plaintiff's expert and the defendant's expert's opinion is that the gross amount you start with will either stay the same or it will go down. Frequently, the expert for the plaintiff will make the argument that it should basically just stay the same, and that's about the best we can do. The defendant will argue that the amount should go down. But most of the time, when you're talking about present value, in a normal personal injury case, you're going to start with the gross amount of the lost wages that you can determine, and or the medical bills that are going to be needed in the future, and that number is going to be ratcheted down. When I say the gross amount, what do I mean by that? Let's just take an example of future lost wages. Let's say that a person is going to lose, it works at a job that makes them $50,000 a year, and they have 10 more years to retirement. 10 times 50,000 is 500,000. So that's the amount you'd start off with as the gross amount. For future medical bills, you're going to have a doctor or you're going to have a life care planner, and they're going to come in and say he needs a surgery, he needs this many visits with the doctor, he's going to need another fusion surgery, he's going to need whatever it is. And we're going to add up in today's dollars what those surgeries and visits are going to cost. And that's the gross amount that you'll have in your life care plan. So that's what I mean by the gross amount. Present value takes that gross amount, and in most cases, in a personal injury case, that amount is going to be ratcheted downward through present value. So how is medical malpractice going to be different? And I told you the key rests with this provision, the pay later provision of 667.7. And I got it up on the screen here. It's a lot of words, but I would like to read it because I think it's important. In any action for injury or damages against a provider of healthcare services, the Superior Court shall, and note that word shall, it's mandatory, at the request of either party, and of course the plaintiff would never request it, it's only the defendant who requests it, enter a judgment order that money damages or its equivalent for future damages of the judgment creditor be paid in whole or in part by periodic payments rather than by a lump sum, if the award equals or exceeds $250,000 in future damages. And it's important to note that's future economic and future non-economic. So all it's got to be is over 250, and the defendant then gets to exercise their right to pay later. In entering a judgment ordering the payment of future damages by periodic payments, the court shall make a specific finding as to the dollar amount of periodic payments which will compensate the judgment creditor for such future damages. So you may ask, periodic payments, well, how long can the defendant in these cases take to pay? A long time is the answer. In a case involving future loss wages, those wages normally go out to the date of the plaintiff's work life expectancy. And you can debate whether that's 62 or 65 or 67 or 70. A lot will depend upon the type of job that the plaintiff has. For example, we at one time had a musician, and the arguments are, hey, Mick Jagger's playing into his 70s, so work life can last much longer than the typical 65. But it really depends on many factors. But whatever that work life expectancy is, the defendant is allowed to take that future lost earning capacity or future lost wages number and make payments typically over the person's work life expectancy. If the person's 20 and they're not going to retire until they're 70, that's 50 years worth of payments, right? What about medical bills? Medical bills is even longer because the medical is typically in a personal injury case or a medical malpractice case is going to last basically until the person dies. So we have to determine what's their life expectancy. And again, you can pull up a life expectancy table, but depending on whether you're a woman or a man, generally that could be, in the early 80s. So depending on how old you find your plaintiff, you could be talking about decades worth of periodic payments that the defendant is allowed to make. So this is just completely unfair for the plaintiff. Instead of getting their lump sum, as in any other case where they get their lump sum immediately, their portion is done over time. And I know all the attorneys in the crowd are probably thinking to themselves, wait a minute, is my attorney fee going to be paid over 50 years? No, that's at least one good thing. The attorney's fee gets taken off the top, case expenses come off the top. And these calculations are only made after that's deducted. So you don't have to wait like Rip Van Winkle here to get your attorney's fee over 50 years. But your poor plaintiff does. The person who's injured is going to have to take those payments over years and years and years. And so we had a recent medical malpractice case. It's a very significant case. We had future wages, future lost wage earning capacity of about $750,000, and we had future medical, our life care plan was around $8 million. This was a case where a doctor had done the routine epidural steroid injection many people get in many, many, many millions of personal injury cases every year. And he basically took the needle and instead of going into the epidural space, which is where you put the steroid, he stuck the needle all the way into the person's spinal cord. And even though he had fluoroscopy, live imaging of everything that was going on, he did not realize his mistake. And he injected contrast dye and steroid directly into our client's spinal cord. So as a result, they essentially had a paralyzed arm and significant damages that were going to result in $8 million was our gross number for our life care plan. And so the defendant, in that case, hired an economist, and the economist put together this report, and their economist was going to, of course, take our $8 million and reduce it to like $2 million based upon her concepts of present value. And I started talking to some of the attorneys that were with me on that case, and I started to say, wait a minute, my lady's not getting a lump sum payment. She's not getting a windfall at the end of her case because these defendants are going to be able to pay over time if the amount's over $250,000. My client's not getting any kind of lump sum for future damages. So where's the windfall? There is no windfall. In fact, if there is a windfall, it's the defendant that has a windfall because the defendant may decide, hey, I don't want to invest in something very safe. I'm going to take those millions of dollars that I'm ultimately going to have to pay the plaintiff, and I'm going to invest them in the stock market. And they can come back actually making money on the deal. So I was sitting there thinking to myself, this doesn't make any sense. Why should the defendant be able to get up and reduce our number to present value? It doesn't make any sense. They're already entitled to pay over time. So there is no windfall. It doesn't make any sense. So as a result, in that case, we adopted some strategies, which I think all of you can adopt in your medical malpractice cases, and they're very effective. And the first one is to file a motion in limine to exclude the defendant's expert from giving an opinion on present value. Now, what we were worried about when we brought this motion is they're just going to come back and say, well, wait a minute, it's speculative. How do we know at the end of the case whether the future damages awarded by the jury will be more than $250,000? So, Judge, it's not fair to grant the motion in limine because we don't know right now. So we should be able to put on evidence of present value. And we knew we were going to say that. So what we did was we offered in our motion in limine the defendant the option to withdraw their CCP 667.7 affirmative defense. The argument being, because we don't know, we could be grossly prejudiced in this case if the jury reduces our number to present value, and then on top of that, if the number's over 250,000, they get to pay over decades. That is a double discount, and that's not fair. So what we're going to do, Judge, because we don't know whether it's going to be over $250,000 or not, is we're going to give them the option. We're going to say to the defendant, withdraw your 667.7 affirmative defense, and then you're good to go. You put on whatever evidence of present value you want, and then it becomes just like a regular personal injury case. But if you decide you're not going to waive your CCP 667.7 defense, then it's only fair that we be able to exclude this evidence, right, of present value because it's not fair and it allows the defendant to, in essence, get a double discount. In addition, in a typical personal injury case, you're going to have a CASI instruction 3904A on present value. We'd ask that the judge not submit that. And in addition to that, one of the things that I think was really important is that before the defendant got wind of our strategy here, what we did is when we got the defendant economist in the deposition, we asked her about 667.7, asked her if she knew about it, and asked her, and if she said, I don't know anything about that, or I'm not a lawyer, then say, okay, well, let's assume for purposes of argument that at the end of this case, the defendant can come back and they are entitled to an order allowing them to pay future wages for decades until work life expectancy and medical bills for decades until the person dies, until their life expectancy. Assuming those facts, Mr. Expert, what would the interest rate be? And of course, the answer is obvious. The interest rate is zero. So the interest rate is zero. And so you ask the expert to assume that what we call the discount rate or the interest rate of a safe investment would be zero because the plaintiff isn't getting a lump sum. They don't have anything to invest. And so because they don't have anything to invest, that number is zero. And so you ask them to assume that number is 0% and then make calculations based upon that. So those are the three strategies that we did. Now we had a case up in Antelope Valley in front of an excellent judge up there. And this judge totally understood everything we were saying. And we won every one of these issues. So he granted our motion to eliminate, told them they could not have their expert give the opinion on present value, right? And that he would not be instructing on 3904A. And he gave them the option to withdraw their affirmative defense. And they said, no, we're not going to withdraw it. And so it worked very great for us in that case. Now, many of you might say, okay, wait, if you're going to give them the option to withdraw their 667.7 affirmative defense, how do you know they're not just going to waive their rights and say, okay, we'll waive that affirmative defense? And the answer is they will never do that. And here's why. So let's assume each one of these green bars is a yearly payment for medical bills that the defendant's going to have to make until your plaintiff dies. The same amount every year. They pay on January 1st, let's say every year. They got to pay him an amount. And this goes until your plaintiff is, say, 82. In year 3, your plaintiff dies. That's how much the defendant has to pay. Yes, it's insane, but the law provides that if your client dies when there's a periodic schedule and they die before the end of the schedule, they die before their life expectancy, all medical payments by the defendant cease. You could die in year 1 or 2 and they don't have to pay any of that. Now, the answer is not the same for future lost wages. The statute provides that if you die early, they have to take your lost wages and give that to your relatives and your heirs. But for medical bills, they can literally stop making payments. If you have a life care plan of $9 million and they make one payment in year 1 and then you die, you don't have to make any of those payments ever again. And what defendant would not love that miscarriage of justice? And so I can assure you that they are not going to waive their 667.7 defense. And the minute they don't waive that, then you have the clear argument to the judge that it would be grossly prejudicial to you to allow their expert to come in and reduce the number to present value. And then on top of that, get a double discount. So we did a little bit of research on this to determine if there was any support for us. And we found out, surprisingly, there was a case all the way back in 1998 from the Supreme Court that supported us. It's called Salgado versus County of Los Angeles. And there's the site, 19 Cal 4th, 629. It's from 1998. And in that case, that was a little bit different in those days because that's when we didn't have the Cassie instruction. And so the instruction at that time was a little bit different. The jury was instructed at that time to make the award of the gross amount and then also in the verdict form give the amount to present value. So it is a little different procedurally because they had a different jury instruction. But the bottom line is what happened is that the jury was allowed to hear present value testimony to reduce the verdict based on present value. And then they wanted to get periodic payments under 667.7. And the court held, no, that's an unfair double discount. And what the court held was that in future cases, you need to go off the gross amount. And the court said, and this is a quote, this is because if a present value award is periodized, a plaintiff might not be fully compensated for his or her future losses. The judgment, in effect, would be discounted twice. First, by reducing the gross amount to present value, and second, by deferring payment. A double discount. The proper approach, said Salgado, is for the jury to determine the gross amount of future damages and for the court, note that, the court to structure a periodic payment schedule based on that amount. And in ruling that way, the court based its decision on two other Court of Appeals decisions. I'll put them up here real quickly for you. It's America Bank and Trust Company versus Community Hospital, 36 Cal 3rd 359. I guess that was Supreme Court. And Holt versus Regents of the University of California, 73 Cal App 4th 871. Where the court held the present value cannot be used as the figure to be periodized. Periodic payments are based on the gross amount of future damages. So when we use these cases, the court said, yeah, you're right. You can't do present value and then periodically discount it after that, because that gives them a double whammy, a double discount. So that's a lot of discussion, but we still haven't heard what is in the title of my presentation, which is how to double your economic damages. We haven't heard anything about that. Well, with that background, now I can tell you how you can double your economic damages in a medical malpractice case. And the short answer is wage growth and medical inflation. So let me kind of talk about those real quick. Okay, again, let's go back to a regular personal injury case. You get hit by a truck. Okay, what happens is that the discount rate, which is the investment safe interest rate, that's the amount that you need to invest so that when you get to the service that you need, you'll have that money at the time, right? We've already talked about that. That's the investment safe rate or the discount rate. But we also have to, when we're talking about future wages, we have to talk about wage growth rates, because it's likely that if you work at a job, you're going to get raises over time. So if we don't include the wage growth rate, that's not going to be fair to the plaintiff. You're going to get underpaid because you're not going to account for the fact that those wage growth rates would increase. Let's say you had a job and you were having $50,000 a year loss. Well, the next year it could be 52 and then 54 and then 56. So because you're going to have future wage increases, that's going to increase your number. So we have to account for that. So what happens is that economists will, if they're talking about future loss wages, will take these two factors, the interest rate for a safe investment, the discount rate, and the wage growth rate. One of them is going to make your gross number go down. Which one is that? Discount rate, right? And the other one's going to make your gross number go up, the wage growth rate. And what you'll normally find is that the investment rate is going to be higher than the wage growth rate. So the net effect, what many economists call the net discount rate, would be the 4 minus, in this case, the 1. This is just an example. 4 minus 1, the net would be 3. So since we have a positive net discount rate, that makes your gross number go down. This is in the typical auto accident case. Okay, now let's talk about medical. Same thing. We all know that the cost of medical services and products will go up over time, right? If you looked at a hospital bill for what an appendectomy would be in 1975, that's going to be a lot lower than what the hospital would be today in 2026, right? And that's because we have medical inflation. Cost of a wheelchair today is going to be lower than the cost of a wheelchair in 30 years, right? So we have to account for medical inflation, right? So when an economist is talking about the net discount rate for future medical bills, they do the same thing. They take the safe investment rate, the discount rate, they subtract the medical inflation rate, and you get a net. And again, unfortunately, most of the time, you're going to find that that results in a positive number because the investment rate's usually going to be a little higher than the medical inflation rate. Okay, so that's ultimately in a regular personal injury case going to cause your gross amount to go down, right? But now, what have we done? In our motion in limine, we've eliminated present value. We've taken this discount rate and we've made it 0. We've made it 0. So now what happens? Now we're in a medical malpractice case. We've won our motion in limine, right? The discount rate is now 0, but now what do we have? Our wages are going to go up and our medical inflation rate is going to go up. And those are things that only make your numbers go up. So now you ask your economist, I'd like you to assume that the discount rate is 0 and assume whatever you think is appropriate for the wage growth rate and for the medical inflation rate. And now take our gross numbers of our lost wages and our life care plan and wave your wand and do your business. And you'll find that when you apply the wage growth rate and the medical inflation rate, the numbers are going to dramatically go up. Let me tell you about a recent case that we just had, the case I was explaining. We had a future lost earning capacity number of $744,000. The number wasn't that great because our plaintiff didn't make that much. We applied a wage growth increase, again, assuming that the discount rate would be 0. And our $744,000 in wage loss went to $1.1 million. Interestingly, when we asked the defense CPA to make that same assumption, her number was 1.05 million. So almost the same thing. She herself had to agree that when we don't have a discount rate and when we have a wage growth number, that's going to make the number go up. Our life care plan was 7.8 million. That was our gross number. When we applied the medical inflation rate to those numbers over time for the rest of her life, the number came out to $21.7 million, almost 3 times the gross number that we started with. And here's the greatest part about this. Here's the absolute greatest part about this. Since we won our motion in limine, they were scrambling at that point because their economist's whole opinion, right, related to present value. She took our $8 million and wanted to reduce it to like $2 million. Well, now what was she going to do? She couldn't let us just come in there with a $21 million number. She had to come up with a number herself, right? So what did she do? This is the defendant's expert. She came up with 6 different tables, okay? And the tables were based on certain assumptions because the parties disagreed on a couple things. We disagreed on life expectancy. We disagreed on whether the plaintiff really needed each item in the life care plan. And with respect to some of those items in the life care plan that were necessary, we disagreed on what the unit cost of those was. And again, we had experts debating those, right? So she took those assumptions and she said, okay, let's say the jury believes the plaintiff on the life care expectancy, but believes us on the other 2 factors we disagree on. And then she'd come up with a number for that. And so she had 6 tables then that went across. The lowest number was $3.5 million. And that was using everything that the defendant's expert said. We don't need any of this treatment. We want to give you low numbers for everything. She's going to have a low life expectancy, whatever. The lowest number was $3 million. The highest number she had was $17 million. So on cross-exam, we went through each one of her tables in excruciating detail and had her start off with 3.4 and then go to 5 and then go to 8 and then go to 12. And by the time she was finished and her final number was $17 million and we circled that, oh my God, it was just brutal. And the way that the defendant tried to stop that when they saw the train coming down the tracks is to just have her give the low number, the 3.4 million, and then stop. And then when I tried to go on cross-examination, say it was beyond the scope of direct. And I said, wait, no. She's got an entire report that we crossed around with 6 tables. I'm entitled to cross her on the entire report that's here. And the court allowed it. And we went through every one of those numbers. And it was like, oh my God, it was just absolutely brutal for the defense. So anyway, really good results from that. And I would encourage every one of you to adopt this strategy because I think it works. I would like to also just kind of give you a final tip. And this is in any kind of case, whether it's, of course, the Medler Law Firm does not only medical malpractice cases, but also does, all kinds of personal injury cases as well. And in many of those cases, you're going to have a life care plan. And I wanted to just give you some tips to make sure when you talk to your economist, and again, also when you're cross-examining their expert, that when you talk about medical inflation, you use blended rates, and I'll tell you what that means in a minute, and you use the longest time period possible. And you'll find that the medical inflation numbers are higher when you use them over a longer period of time. So we use 60 years in our cases, but our expert can say, here's what it would be at 60 years, here's what it would be at 50, 40, 30, 20, 10. And they can give numbers for each one of those so the jury will like them. But let me tell you real quick, what I mean by blended rates. So when you want to figure out, well, what was the medical inflation rate for the last 10 years? The United States government has statistics that they publish that you can get these off without any problem, and your economist can get them too. And they have statistics for the CPI for medical inflation. And what's important is that they have subcategories of the medical CPI. To give you an example, they're going to have a CPI, an inflation rate figure per year, every year, for all medical in general, everything under the field of medical. But they're also going to have a subcategory of the CPI for hospital bills or for medical commodities, which are like wheelchairs or Band-Aids. They're going to have one for professional services for a doctor if you're going for a doctor visit. And they have separate rates for each of those. And the reason it's important to use those subcategories is because for certain categories, the inflation rate is way higher. And when I say use blended rates, that's what I mean. So your economist should go through the life care plan and take all the stuff out relating to hospitals, and then take all the stuff out relating to professional visits with doctors, take all the stuff up for commodities, take all the stuff up relating to compensation, and then put those into separate buckets and apply the medical inflation rates for each of those buckets. To give you an example, here's something that our expert used in the last case. And you can see we've got an all items and medical services over here, which are more generic. But if you look at the interest rate for hospital services as one example, it's 7.4%. That's a huge number, right? So if you have a client who on their medical life care plan is going to have a lot of future care going to the hospital, you for sure want to use the separate one for hospital services because that inflation rate will be ginormous. And so what we had our expert do is to use the different subcategories of the CPI for the different categories of our life care plan. So that's just a kind of a final tip. I have copies of our motion to eliminate that we filed in that last medical malpractice case. I've got copies of the deposition transcript of their economist. I've got copies of their experts' expert report with the tables in it, and I've got a copy of our experts' reports. If anybody is interested afterwards, you want to send me a private email, I'd be happy to give you those that you can use as samples in your cases. But I feel confident that this strategy is going to work for anybody who's got a medical malpractice case and is interested in making their economic damages go up. And that's it. If anybody else has any questions, I'd be happy to field any questions from the crowd.
All right, it looks like we have a couple questions here, one being from Cedar Boshan. As a damages expert outside of the world of personal injury and medical malpractice, I have studied economics and am an accountant, but not a CPA. Some present accountants and economists are CPAs, but public accounting is very different. It has a different specialty than damages. All right, let's see. Actually, no, this is more of a comment. Secondly, though I'm not a medical malpractice personal injury, I don't understand why damages experts weren't forecasting for inflation already. Is it not standard in medical malpractice to calculate inflation?
It is. It is. But I wanted to make it clear. It's standard for experts to calculate inflation. And that's when I was talking about when we talk about the two rates, we talk about the safe interest rate, right? The discount rate which is then compared with the medical inflation rate, and they compare those. But the point is that what will frequently happen is when you compare them and you have the medical inflation rate and the discount rate, what will often happen is that will nevertheless cause your number to go down. You'll see that the defendant's expert will come in and even accounting for medical inflation will say that your gross amount is going to go down. And so what I'm talking about, what's unique, I'm talking about in this perspective is to say that we're taking the left-hand side of the equation, which is the discount rate, and we're zeroing that out. And that makes a huge difference because then the regular medical inflation rate that we're already taking into account, then that's allowed to fly free. And that's what makes the damages amount go up. I did want to cover one other additional point. What happens if on the rare scenario that the defendant were to waive the affirmative defense? If the defendant were to waive the affirmative defense, then of course, then it would just be like any other personal injury case, of course, and you'd have present value calculations just like normal. But what happens if after the verdict is over and the judge has excluded present value, they decide not to exercise? I don't know why they would do this, but let's assume they decide not to exercise their rights, or let's assume that the damage amount comes in under $250,000. What would happen then? What would happen then is the teaching of Salgado is that the experts from both sides would then submit post-judgment declarations to the judge, and the judge could then reduce that verdict accordingly based upon whatever the judge deemed to be appropriate, and the judge would then reduce it to present value. That would be a case where there's not periodic payments, and that they either elected not to choose that or that the amount came in under $250,000.
All right, so it looks like we have another question from Mal Dalswin. Are there any standard text or cliff notes type of guides that you would provide a numbers phobic attorney a succinct understanding of these statistical methods you reference?
Yeah, one thing I can do is one good thing is we used an expert in our last case who had sort of a boilerplate that he put in all of his opinions, and it goes on for about 20 pages, and it's a really good primer on just sort of like the simple, he explains in a kind of C-spot run language to kind of understand what's a discount rate, what's a medical inflation rate, how do we figure that out? And he explains it in very clear language, and I can give you a copy of that. I found it very helpful in my case because I felt like he kind of put everything in very, very simple terms for people to understand. But I know some people are just not numbers people, and this becomes very difficult to understand. But just to keep in mind the kind of general picture is that if you have a regular personal injury case, you're going to be talking about present value because you're going to get that whopper load of money relating to your future damages all in your pocket at one time. The plaintiff's going to get a lump sum. And so the concept of that is that you can then invest that even if you go totally safely over time. So you don't actually need that much because you can invest it over time. What we're saying here is in a medical malpractice case, that whopper load of money, that's sitting in the defendant's pocket, not in your pocket. The defendant gets to invest that wherever they want to. They're the ones that can make the windfall on this. So it's not fair to have present value in a medical malpractice case where there is no lump sum. That makes sense.
All right, thank you. And then we have another question from Rachel Kogan. What is the best argument for the defense for limiting economic damages? What should the defense pay for medical expenses after a plaintiff dies? Wouldn't that be a windfall for the plaintiff?
Well, I would argue that it's not a windfall for the plaintiff because we don't know when the plaintiff's going to die. You know, the plaintiff could live past his life expectancy. So let's imagine somebody who has a life expectancy to live till they're 80 and they live till they're 90. They still have medical bills from 80 to 90, don't they? We don't know when they're going to live, right? And so the argument is, in a regular personal injury case, it's fair to give them all the money right now because we don't know when they're going to live, and they could be underpaid if they end up living past their life expectancy. In this particular case, one of the arguments that doctors made that got put into the law was this argument you're saying that they could, in essence, get a windfall if they ended up dying early. And my argument is that if a doctor is going to commit gross medical negligence and cut off your right arm when it should have been the left arm, I think he should end up bearing the burden of how long the plaintiff is going to live. I don't think it's fair to say that because, oh, whoopee, the plaintiff only lived 2 years, now I get to pocket the rest, and the doctor's essentially gotten off with gross medical negligence. That amount should be there for that person's heirs. They were damaged, and they should get all the damages, in my opinion, they're entitled to. Now, if you're looking about what's the best argument for the defendant, that's not really my thing because I'm a plaintiff's lawyer. But the defendant, I think the best argument to try and combat what we're doing here is to argue what I said before, that it's speculative whether the amount will come back under or over 250,000, and therefore the defendant, I think, would argue that we should still be able to put in present value because we don't know what's going to happen. And if it comes out against us, then we've lost our opportunity to put in the present value number. I think that's what the defendant would argue. That was unsuccessful when we argued it in our case. And I think the judge came out the better way, which is to say that they have every opportunity to level the playing field right now is by waiving their 667.7 defense. And if they just decide they're not going to do that, then we shouldn't have to bear the risk of that. So I think that's the correct ruling, and we'll see what happens.
Thank you, John. It looks like we have another question from James Yee. Have you ever been awarded punitive damages? If so, what was the winning argument there?
Yes, we've argued punitive damages, but the winning argument has to be that it's just really egregious. As you know, the thing that is the standard for punitive damages is whether it's basically outrageous. And most of the time you're not going to be able to get punitive damages in a med mal case because usually the doctor is trying to do the best he can. What if a doctor was drunk, right, and went into a surgery, right? That would be a clear case of outrageous behavior that would warrant punitive damages. I've had it before, but I will tell you it's extremely rare that you're able to get punitive damages. And if you're working on a med mal case right now where you allege punitives, they usually almost always will come up with a demur to the punitives right in the beginning. And then at that point, unless you got something really good, like the doctor was drunk, you're probably better off taking the punitive damages out of your complaint and then just waiting because you can always add it later. And if you develop some kind of evidence that would establish a basis for outrageous conduct on the part of the doctor, then you can add it later.
Thank you. Philip Vondrazak is asking, any reading materials that you'd recommend on the topic?
I think, let's see. Like I said, I think that it would be really helpful to look at the pleadings that we filed in that case, as well as our experts' report in that case, which you give kind of a primer on economics. I also think it's worthwhile to read the Salgado case and the two cases I mentioned that are cited in there in great detail, because I think you'll learn a lot reading those cases about the rationale. The argument the judge was making, that the Supreme Court made in that case, is that it really is a double discount. If you allow them to introduce evidence of present value, it's reduced once, and then you pay over time. That's reducing it twice. And I think the Supreme Court was on very solid ground saying that's a double discount. And so you can't allow that. So you got to get the first part out by getting the present value information out.
Great, thank you. Let's see. Would you say there are any recent cases or trends suggesting courts are pushing back on this approach?
It's interesting. It's interesting. We called a number of med mal lawyers before we did this, and not only I did it, but my co-counsel did, because I kind of thought I was losing my mind. I was like, why hasn't this been done? I don't understand how they're allowed to bring in present value. It doesn't make any sense to me. And nobody was doing it as far as I know. Nobody was excluding present value. And I looked for case law and it kind of ends with Salgado. There's not a lot of case law that goes beyond that. Um, so I don't think I'm not aware of any recent court trends about whether this approach is good or bad or ugly. Um, but to me, it follows Salgado, which is Supreme Court, and it makes perfect sense. And frequently, I think if you make that argument to the expert, to their expert, when you're cross-examining their expert, and you say, let me see if I get this right, Mr. Expert. The reason that we're doing present value is because normally the plaintiff gets a lump sum even of their future damages, and it's not fair to give them something that they may not need for 10 years and give them that today when they can invest it over the next 10 years and make money. Isn't that the concept? And they'll say, yes. And then say, well, you're aware in this case that there's a high likelihood that the defendant is not going to have to give this in a lump sum. The defendant's going to be able to pay this in tiny increments over a long period of time. And they go, I'm not aware of that. Well, let me show you 667.7. And you show them the thing, and they say, now that you've seen that, if you would assume for me for a minute, doctor, I'm sorry, if you would assume for me for a minute, Mr. Expert, that there is going to be no lump sum, then you'd agree then that the discount rate should be 0, correct? I guess so. Well, let's do a little hypothetical. Let's assume the discount rate is 0. We still have medical inflation. We still have wage growth. I'd like you to recalculate your numbers if you would, using those assumptions. Now, if you get lucky, they'll do the calculations right at the table. I've had a lot of the more cagey experts, so at that point will say, well, that would take me time. I'd have to go back to the workshop and do those calculations there. But I've had cases though where when I've asked economists to assume different sets of numbers, and they just pulled out their calculator and did it right there. It's not that difficult of a calculation, typically speaking, especially when you're talking about wages. The medical inflation is a little bit more difficult because then you're parsing out the different subcategories, so then it gets a little bit more complicated. But if you can get their expert then to basically do the new calculations, I mean, you're golden. That's I think a big mistake they made in our case is by trying to rebut what we were saying by assuming our assumptions and them giving new numbers, because it resulted in their own expert saying numbers like $17 million.
Thank you. And it looks like we just have one question. Let's see. Maria Ty is asking, I joined late. How is emotional damage correlated with physical damage?
How is emotional damage correlated with physical damage? Well, obviously, in any kind of a personal injury case, including medical malpractice, you can have emotional losses as well as personal losses. But generally, what you're talking about there is non-economic damages. And as you know, in a medical malpractice case, those are limited by statute. So what this seminar was talking about was how you can take the part that's not limited, meaning economic damages, which would be your lost wages, future lost earning capacity, and future medical bills. And you can use a technique that we've talked about in this seminar to dramatically increase those numbers by increasing them through wage growth and inflation, but without a discount rate, with a 0% discount rate.
Great. That looks like that's it for questions now. Do you have any other concluding remarks that you'd like to make?
No, just like to, again, my email is up on the screen, john@medlerlawfirm.com. And if anybody wants to send me a private email, I'd be happy to send them those documents to get you started. Thanks very much.
Thank you. This concludes today's presentation. Thank you so much, John Medler, for an excellent presentation. And thank you so much to our audience. Have a great day, everybody.
Thank you.